Today's class is on judicial activism in India. In fact, this is very lengthy chapter as well as very important also. Due to time is less, to complete the preparation, you have to select the key topics from this chapter. What are the key chapters? Key topics means first one, relevant terms and expressions, and the second one is general role of judiciary, and the third one is idea of framers of the constitution, and the fourth one is that reasons for judicial activism, and the fifth one is reasons for emergence of public interest litigation in India, and the sixth one is that socio-economic justice and the role of public interest litigation, and the seventh one is that uniform civil code and the role of Supreme Court of India, as well as curative petition and complete justice, as well as the role of judiciary in unearthing the black money, etc., including relevant articles as well as relevant case laws and the model questions from this chapter, as well as previously asked questions from this chapter. These are the key topics from this chapter you have to select to get good score in the UPSC prelims. First one, relevant terms and expressions. What are the relevant terms and expressions means? From this chapter, the relevant terms and expressions are what is judicial review and what is judicial restraint and what is judicial activism, what is the difference between the judicial review and the judicial activism, and what is judicial power, and what is judicial policy making, and what is constitutionalism, and what is public interest litigation, as well as separation of powers between the major organs. These are the relevant terms as well as expressions. And what are the relevant articles? Means Article 13 and Article 32, Article 44, as well as Article 142 and Article 226. These are the relevant articles related to this chapter, judicial activism in India. Next one, relevant case laws. What are the relevant case laws means? First one is Case Swananda Bharati. It is filed in 1970, but judgment rendered in 1973. And the second one, Mumbai, that is Kamagar Society versus Abdul Thai. Mumbai Kamagar Society versus Abdul Thai in 1976, as well as Husainara cartoon versus State of Bihar, and Rupa Ashok Hura versus Ashok Hura. This is means that is Mumbai Kamagar Sabha versus Abdul Thai. Judgment rendered in the year 1976, as well as Husainari Cartoon versus State of Bihar. The judgment rendered in the year 1979, as well as Rupa Ashok Hura versus Ashok Hura. The judgment rendered in the year 2002, and Sarala Mudgal versus Union of India, judgment rendered in 1995. And the last one is Ram Jatmalani versus Union of India, and the judgment rendered in the year 2011. These are the relevant case laws related to this chapter, Judicial Activism in India. So, first one, what is judicial review? You know that in view of Article 13, the law passed by the legislature cannot override the fundamental rights, as well as the executive action of the government is also cannot override the fundamental rights of the citizens granted by the Constitution of India under Part 3. Under Part 3. Or in Part 3 of the Constitution of India. So, if there is effect to the fundamental rights granted to the citizens by the Constitution of India, then what the citizens to do? How they will get the relief? Who will correct this action of the state? Means only judiciary. Only judiciary. So, judicial review means it is to test the validity of the law passed by the legislature, as well as to test the executive action of the government, whether it is overriding the fundamental rights or not, or whether that law is correct or not. This action of the judiciary is known as judicial review. But how this matter will come before or will place before the judiciary means the affected persons must approach the judiciary seeking the judicial review under Article 226 before the High Court, as well as under Article 32 before the Supreme Court of India by way of writ petition. Once the writ petition is filed before the judiciary, the judiciary will start the judicial review. Judicial review. This process is called as judicial review. Judicial review. Next one, judicial restraint. What is this judicial restraint means? Self-discipline as well as self-control is essential for the development of every human being as well as every organization or organ of the state. So, this self-control exercised by the judiciary is called as judicial restraint. Is called as judicial restraint. And the third one is judicial activism. What is this judicial activism? Judicial activism is nothing but the extension of judicial review. Extension of judicial review. Already I told you that under the judicial review, the judiciary will test the validity of the law passed by the legislature, as well as will can test the executive action of the government. If the affected person placed the issue before the judiciary by way of a writ petition. But here, in this judicial activism, judiciary itself can test it without any writ petition in the interest of the larger public or in the interest of group of people by way of sumoto or by way of public interest litigation. Occasionally, we are seeing in the newspapers that a case filed by the judiciary as sumoto writ petition. Recently, also one case filed that is related to social media postings. That is also filed as sumoto writ petition. So, under the judicial activism, the judiciary itself can file the writ petition either in the interest of the judiciary or in the interest of the public or in the interest of the group of people. It is to test the validity of the law passed by the legislature or executive action of the state. This process is called as judicial activism. So, judicial activism is nothing but extension of judicial review. But here we have to understand that few high courts are there, as well as in entire India only one Supreme Court is there. So is it possible to the judiciary to focus on all these issues? Means it is very difficult to do it. So very firstly, in 1976, public interest litigation was introduced at Supreme Court of India. That is in the case of Mumbai Kamagar Sabha versus Abdul Thai. And the judgment rendered in the year 1976. 1970. It is filed in 1976. It is related to Bonus Act. Bonus Act. Thus, the public interest litigation was introduced in judiciary in the year 1976. But the first public interest litigation means the judgment passed in the first public interest litigation in India is Hussainari Cartoon versus State of Bihar. Hussainari Cartoon versus State of Bihar. It is related to inhuman conditions of prisoners. Inhuman conditions of prisoners. So, what is the difference between the writ petition and the public interest litigation? Mean, if the affected person itself file a writ petition before the judiciary under Article 226 or under Article 32, it is known as writ petition. If the same writ petition filed in the interest of the larger public or in the interest of group of people, it is called as public interest litigation. It is called as public interest litigations. So, very firstly, public interest litigation system was introduced in Supreme Court of India in the year 1976 by the case Mumbai Kamagar Sabha versus Abdul Thai. Abdul Thai. So, this is the difference between writ petition as well as the public interest litigation. Now, the next one is judicial power. What is judicial power? Judicial power means being as one of the organ of the state, the judiciary has some powers because the role of judiciary is to guard as well as to protect the fundamental rights of the citizens. So, it is the duty of the judiciary to protect as well as to guard the fundamental rights granted by the Constitution of India to its citizens. So, being as one organ of the state, the judiciary has some powers. The powers used by the judiciary to protect and to guard the fundamental rights or other rights granted by the Constitution to its citizens is called as judicial power. Judicial power. And the next one is judicial policy making. What is this judicial policy making means? Judges do not merely declare the law. Judges also creators of law. Creators of law means they cannot pass the acts or they cannot pass the laws because that is the duty of the legislature. But they can give the guidelines to the state to promote the fundamental rights or to develop the implementation of fundamental rights. So, in that case, the judiciary can give guidelines to the state. Recently, Supreme Court has issued some guidelines against the sexual harassment of women at working places, as well as Supreme Court has issued guidelines in some other issue, that is adoption of children by the foreign parents, and the third one is guidelines on speedy disposal of criminal cases. All these are comes under judicial policy making. That is the difference between judicial activism and judicial policy making. And the next one is separation of powers. I need not explain more about this separation of powers because I thought you read well about this issue, about this subject. That is, there are three organs known as legislature as well as executive and the judiciary, and each organ has its own powers as well as its own arbit, and no organ should encroach its border or no organ should encroach the sector of other organ. So, this is known as separation of powers. Separation of powers. And the next one is constitutionalization. What is this constitutionalization? Means spirit of constitution that commands respect from the rulers as well as ruled. It is known as constitutionalization. This is known as constitutionalization. So, these are the relevant terms and expressions as well as articles and as well as the relevant case laws from the chapter Judicial Activism in India. And the next topic is that general role of judiciary. What is the general role of judiciary? The role of judiciary, general role of judiciary is that to guard and to protect the fundamental rights and to test the law passed by the executive and to test the validity of the executive action of the government and to interpreting the Constitution of India and to implement the laws passed by the legislature. These are the general role of judiciary. These are the general role of judiciary. And the next one is idea of framers of the Constitution. Here, to expect or to assess the idea of the framers of the Constitution of India, we have to go through Article 142. Article 142. Because this article has given unique power to Supreme Court to do complete justice. To do complete justice. So, according to this article, we can estimate the idea of the framers of the Constitution of India that their idea is to place the judiciary as at the top. They want to place the judiciary at the top out of the remaining organs. Because the duty of the judiciary is to protect the fundamental rights. As well as they made the Supreme Court as the final final arbiter to settle the federal issues and to protect the fundamental rights of the citizens. So, the framers of the Constitution have given unique powers to Supreme Court of India, means judiciary, to do complete justice under Article 142. And the next one is reasons for judicial activism. Already I explained you about what is judicial activism and the difference between the judicial review as well as the judicial activism. Now, reasons for this judicial activism means what are the reasons causes the judicial activism means, you see, first one, near collapse of responsible government means at the time of confidence motion or at the time of no confidence motion, if the action of the speaker or if the action of few of the members of the legislature causes collapse of responsible government, at that time the role of judiciary is essential under judicial activism. So, near collapse of responsible government is one of the reasons for judicial activism. And the next one is judiciary to step in aid. You know that Article 39A provides free legal aid to all, as well as according to Article 14, before the law all are equal. All are equal. So here, when the rights of the citizens are affecting, or when the rights of the when fundamental rights are affecting, then being as a guardian of the fundamental rights, the judiciary can provide its aid to the affected persons. So, this is also one of the reasons for judicial activism, means judiciary to step in aid is another reason for judicial activism. And the third one is that to participate in social reforms and change. Already I explained you about judicial policy making. Judicial policy making. So, if the judiciary want to bring reforms as well as change in the society, there is a provision under judicial activism. So, this is also one of the reasons for judicial activism. And the next one is legislative vacuum left to open. This is the main reason for judicial activism. This is the main reason for judicial activism. That is, if the legislature vacuum left to open, there is a chance for judicial activism. And the next one is constitutional scheme. This is also one of the reasons for judicial activism. And the next one is to validity the law, means to test the validity of the law passed by the legislature or to test the executive action of the government. as well as the role as guardian of fundamental rights. This is also one of the reasons for judicial activism. And the last one is enthusiasm of individual players. These 9 are the main reasons for judicial activism in India. Judicial activism in India. Next one, what are the reasons for emergence of public interest litigation in India? Already I explained you about the public interest litigation. What is the difference between the writ petition as well as what is the difference between the public interest litigation? So here, now what are the reasons for emergence of public interest litigation in India means these are the main reasons. Nearly 7 reasons are there. First one is socially and economically disadvantaged position. Already we discussed that according to Article 14, all are equal before the law. So if all are equal before the law, if there is any socially and economically disadvantaged position is there, that shall be one of the reasons for public interest litigation. As well as another one is rights of taxpayers. If the rights of the taxpayers are affected, then they can move either the High Court or the Supreme Court under the public interest litigation or by way of the public interest litigation. This is also reason for public interest litigation. And the third one, injury to public interest. As I told you, if the group of persons' rights are affected or larger number of people's rights are affected, then any public spirited person or the NGO can file a writ petition before either the High Court under Article 226 or before the Supreme Court under Article 32 by way of public interest litigation. So the injury to public interest is also one of the reasons for public interest litigation, as well as organized social action is one more action, and the court willingness to innovate. The court's willingness to innovate is one more reason for the public interest litigation, means emergence of public interest litigation in India. And the judicial activism is also one of the reasons for emergence of public interest litigation in India. And the last one is 42nd Amendment, which is known as the Constitution Act 1976, is also one of the reasons for emergence of public interest litigation in India, because the main aim of this 42nd Amendment is that to reduce the powers of the Supreme Court, as well as through this amendment they introduced the fundamental duties to the citizen, as well as they added the words, those are secularism and socialist, as well as integrity, to the preamble of the Constitution of India. So this is also one of the reasons for emergence of public interest litigation in India. Next topic is that socio-economic justice. Socio-economic justice and the role of public interest litigation. So what are the socio-economic justice? In the matters of socio-economic justice, what is the role of the public interest litigation? We have to see. See, prisoners' jurisprudence. Prisoners' jurisprudence is also one of the socio-economic justice. Means it is for either the prisoners' jurisprudence or for the labor jurisprudence or for the prisoner's right, means to protect the prisoner's rights, as well as to protect the consumer's rights, as well as to protect or means to make the pollution-free environment, and for the compensatory jurisprudence, and for the rights of health and medical treatment and for the rights of children and women and for the independence of judiciary as well as to enforce the rule of law. All these are known as socio-economic justice. So, to seeking relief in socio-economic means seeking relief for socio-economic justice, you can move a public interest litigation before either the High Court or the Supreme Court. So, this is socio-economic justice and the role of public interest litigation. Already I explained you the first public interest litigation that is decided in the year 1979 in the case of Hussainari Khatun versus State of Bihar. That is, the inhuman conditions of the prisoners is the subject of that case, and that is the first PIL in India. So, to expect the socio-economic justice, you can move a public interest litigation before either the High Court or the Supreme Court. The next one is that Uniform Civil Code and the role of Supreme Court of India. In Part 4 of the Constitution of India and in Article 44, means Article 44 directs the state to implement the Uniform Civil Code in the entire territory. But unfortunately, it is not happening. It is not happening. And also, it is essential. Otherwise, the article, there is no meaning for Article 14. Until unless there is no Uniform Civil Code, there is no complete meaning for the Article 14. Hence, in the case of Sarla Mudgal versus Union of India, decided in 1995, Supreme Court directed the Union of India to implement Uniform Civil Code. Uniform Civil Code in view of Article 44. In view of Article 44. So, not only in that case, and also in many cases, Supreme Court used its power exercised under Article 142 and direct the Union of India to implement the Uniform Civil Code. Recently, in the matter of Ram Janmabhoomi also, Supreme Court utilized its power under Article 142 and appointed the Ram Janmabhoomi Trust for the construction of that holy temple. So, this is the Uniform Civil Code, which is essential to do complete justice to Article 14. Article 14. And the next one is that curative petitions. Curative petition. What is this curative petition? You know that if you are not satisfied with the order or the judgment passed by either the High Court or the Supreme Court, you can file an appeal before the Supreme Court. But if you are not satisfied with the judgment or order passed by the Supreme Court, what you have to do, because that is the final court. That is the final court. So, here you know that Supreme Court, the jurisdiction of Supreme Court is classified as original jurisdiction as well as appellate jurisdiction and advisory jurisdiction and also revisionary jurisdiction, etc., etc. But here, if there is no appeal provision and if you are not satisfied with the judgment passed by the Supreme Court because there is some erroneous in that judgment, then what you have to do means till 2002, there is only one provision that is known as review. If you are not satisfied with the judgment passed by the Supreme Court, then you have the only one provision that you have to file the review petition. And the review petition will be listed before the same judge who passed the earlier judgment. If the review in that review the previous earlier judgment corrected, it is okay. Otherwise, it is the ultimate. But in 2002, in the case of Rupa Ashok Hura versus Ashok Hura, Supreme Court introduced the curative petition. According to this curative petition, if there is any erroneous or violation of law or violation of the fundamental rights observed, means it is to be observed by way of certificate by the senior advocate on record. Based on the certificate by the senior advocate on record, the curative petition will be moved by the advocate on record before the larger bench. And the larger bench will see it and will do the correction. It is nothing but one type of appeal. One type of appeal. So, very first time in the 2002, by the case Rupa Ashok Hura versus Ashok Hura, Supreme Court introduced this curative petition in the Supreme Court of India. And the next one is role of judicial activism, unearthing black money, etc. So, what is the role of Supreme Court to unearth the black money? Means we already discussed about that judicial activism. Under the judicial activism, to unearth the black money, Supreme Court appointed one committee, means a special investigation team headed by the retired Supreme Court judge to unearth the black money. To unearth the black money. In the case of Ram Jethmalani versus Union of India in the year 2011. In the year 2011. Under the process of judicial activism. So, the judicial activism can be used to unearth the black money also. That was proved by the Supreme Court in the year 1995 in the case of Ram Jethmalani versus Union of India. Union of India. So, these are the important topics in this chapter, judicial activism. Once I will repeat the important terms and expressions, that judicial review and judicial restraint, as well as judicial activism and judicial power and judicial policy making and constitutionalism and separation of powers, as well as the public interest litigation. And the important articles are Article 13 and Article 44 and Article 142, Article 44 and Article 32 and Article 226. Article 32, Article 13, Article 32, Article 44 and Article 142 and Article 226. These are the relevant articles, and the relevant case laws are Keswananda Bharati's case. You know that why this Keswananda Bharati's case became familiar in 1973 means after this case the judicial activism got wide publicity, because in this case Supreme Court declared that the Parliament cannot pass the law or the action of the executive action of the state cannot override the fundamental rights of the citizens, or that action or the law cannot against the preamble of the Constitution of India. So, since 1973, the judicial activism got good publicity. Hence, this Keswananda Bharati's case became very familiar in 1973. And the next one is, already I told you, Mumbai, Kamagar Sabha versus Abdul Tai. It is related to public interest litigation. And Hussain Cotton versus State of Bihar, it is also related to public interest litigation. This is the first public interest litigation in India. As well as I explained you that Ropa Ashok Hura versus Ashok Hura, it is related to curative petition and decided in 2002. As well as Sarla Mudgal versus Union of India, it is related to Uniform Civil Code and decided in 1995. And one more case that is known as Ram Jathlani versus Union of India, it is decided in 2011 and it is related to judicial activism and in unearthing black money. Unearthing black money. These are the relevant cases. So, read well and get good marks. All the best. Bye.